Welcome everyone to our annual Supreme Court review of the highlights of the October term of 2021 and a preview of 2022. I'm Steve Wells. I'm the chair of Dorsey's appellate practice here. And for the past several years, I was usually joined by Tim Drosky, who has now moved on to become the commissioner of the Minnesota Supreme Court. So we missed him, but we welcome Nick Bullard and Ian Blodger, who are also parts of the Dorsey Appellate Practice Group. And you may recognize their smiling faces because they are the people who are the principals behind the Dorsey e-update on the Supreme Court decisions that come out during the year. Thanks also to Brock Hubner, who just joined us recently and who has helped us with this presentation. Let me just make a few remarks before we jump in here. I have a lot of friends who love college football, and they love college football regardless of whether their team is a contender or is in a rebuilding mode. And they say they love autumn because it smells like football. Well, to us court watchers, we feel the same way. Whether you think this court is getting the court back onto the track and getting America back to where it should be, or whether you think it's veering wildly off track, the reality is that the work that the court does is important and profoundly interesting. And we're going to be talking a little bit about the blockbuster decisions from last term and the decisions that we know that the court will take up this term. So with that, I'm going to turn it over to Nick, who is going to go through give you kind of a statistical analysis of the last term. Nick.
Thanks, Steve. Well, it's a pleasure to be with you all this afternoon. And as Steve mentioned, before we dive into the cases, we wanted to give you an overview of some of the statistics from last term and maybe suss out some themes and some trends that have emerged. So the first trend I want to talk about is the decline in decisions. But very simply, the Supreme Court is deciding fewer and fewer decisions every year. In the last term, they decided just 58 signed decisions in fully argued cases. And I want to give you 2 points of reference to understand really how low that number is. The first is the last time the Supreme Court was deciding less than 60 cases was the Civil War. And the second is as recently as the 1980s, just 40 years ago, the Supreme Court was deciding 150 cases per term. So in about 40 years, the Supreme Court has gone from deciding 150 cases to deciding just about 50 cases. So a major reduction in the caseload. And I will note, in preparing for this, despite there being fewer decisions, the decisions get longer and longer. It seems we've had multiple 100-page decisions that we will attempt to go through more expeditiously than that. The second theme, the court continues to reverse lower courts at a very high rate. In the past term, the court reversed the lower court decisions at a rate of 82%. So 82% of the time, the court was flipping the judgment of the lower court. And that's consistent with what we've seen in prior terms. So in 2020, the term before, the reversal rate was 80%. And in 2019, it was about 70%. So very high reversal rates. As a practical matter, what that means is if the Supreme Court grants review in a case, it's very likely that they're going to reverse. Okay, third theme that I want to talk about relates to the red wedge in this pie chart. This is the rise of the 6-3 court. With the additions of Justices Kavanaugh and Barrett to the Supreme Court, we have 6 Republican appointed justices, 3 Democrat appointed justices, and as you can see, in about a third of the decisions, the Supreme Court is deciding the case 6-3. And I'll tell you, in the vast majority of those 6-3 cases, they're splitting along ideological lines. This is a new theme we're seeing. Fourth and final theme is a decline in unanimity. In the last term, the Supreme Court was unanimous in just 29% of the decisions. And I want to stress here that this is a broad definition of unanimous. This could be either unanimous in part, in the judgment, or in full. And so in just considering all of that, they're only unanimous in about 29% of the cases. This is a 20-year low for the court. One note of caution on this stat, some commentators have observed, and I think it's correct, that this might be partially tied to the reduced caseload. The court is granting review in fewer cases, and those cases tend to be the hardest, most contentious cases. So it's not all that surprising to see fracturing and lack of unanimity, as the court is just frankly handling less cases. Okay, with that, I want to dive in and just briefly look at a couple of the specific justices. Chief Justice Roberts on the left and Justice Kavanaugh on the right. These two justices were most often in the majority. They were in the majority 95% of the time. And just as a little bit of a spoiler, you're going to see these two gentlemen smiling faces on a lot of the slides, because they are in many ways are at the middle of the court now. They were most often in the majority in divided cases as well. In 93% of the divided cases, so those cases that were not unanimous, these two justices were in the majority. They were also the two justices that were most likely to agree. I thought this was pretty striking. These two justices last term agreed 100% on the outcome of the case. So reverse or affirm, they were in agreement 100% of the time. And they joined each other's opinions in full and over 85% of the time. So these two justices are writing in tandem and really seem to see the world in pretty similar ways. The Chief Justice authored the most majority opinions in the closely divided cases, the 6-3 and 5-4 cases. And by contrast, Justices Breyer and Justice Kagan authored the most opinions in the unanimous cases for the court. On the topic of dissents, Justice Sotomayor once again had the most dissents. She's held that honor for the last several terms. She was in dissent in 58% of the cases. So over half of the time, Justice Sotomayor is writing a dissent. And there are those two gentlemen again. They are least often in dissent. They were in dissent in just 3 cases each last term. So just some high-level takeaways from these statistics. As I mentioned, the court continues to decide fewer cases. And in those cases, the court is not reaching unanimous results, and that's happening at an increasing rate. Third, I think it's fair to call Justice Roberts and Kavanaugh, whether you call them the swing justices or the justices at the middle, they're clearly in the middle of the court. The best predictor at this point of how the court is going to come out is where are those two justices voting. That's almost always going to tell you, at least based on the last few terms, where the court is headed. And finally, there's a clear conservative majority. That's the rise of the 6-3 court that I mentioned. So with that, we're going to dive into some of the actual cases, and I'm going to hand it off to Ian Blodger.
Before, just one reminder before Ian starts in on the cases. So we have a webinar audience and a live audience. There are sign-up sheets for both. Just remember to do the CLE sign-up sheet so that there's a record of your attendance. And let me say, for the people who are here, we are delighted to see human beings in front of us live and not your avatars. Ian.
Thanks, Steve. Thanks, Nick. So the first case we're going to discuss today is New York State Rifle and Pistol Association versus Bruin. This is a significant Second Amendment case that the Supreme Court handled last term, and it's important because the court re-articulated the test that it will use to determine whether a regulation of firearms violates the Second Amendment. In particular, at issue in this case was a New York statute that had been in existence for in a variety of forms since about 1913. Basically, the statute required anybody who wanted to go out in public with a firearm to obtain a license, a specific license. In order to obtain that license, the person had to show a particularized need for the weapon. So living in a high crime area or walking through an area that had a significant amount of crime wasn't enough. You had to show, in general, that you were subject to specific and repeated threats of violence or bodily harm. So as you can imagine, a number of the petitioners in this case sought a license and were denied and appealed all the way to the Supreme Court, seeking a review of the statute. in a 6-3 majority authored by Justice Thomas and joined by Justices Roberts, Alito, Gorsuch, Kavanaugh, and Barrett. Just like Nick said, this is that 6-3 majority. The court invalidated the New York statute requiring the applicant to show proper cause or show a particularized need for a weapon. What's interesting is how the court got to that conclusion. So after 2 landmark cases about a decade ago, DC versus Heller and McDonald versus Chicago, in which the Supreme Court recognized an individual right to keep and bear arms under the Second Amendment, the circuit courts around the country adopted a 2-part test to determine whether a firearm regulation was in compliance with the Second Amendment. The first part of that test was a history and tradition test. The courts looked to whether or not the firearm regulation at issue was of the type that would have been in existence around the time the Second Amendment was adopted. And if it was, the regulation was allowed to proceed because it was part of the traditional understanding of the right to keep and bear arms. If not, before Bruin, courts would go to a second step, which was called the ends means balancing test, where the court would look to whether the right being regulated was at the core of the Second Amendment right, for example, keeping a firearm in your home, or whether it was more of a tertiary right, keeping a firearm outside of the home for a different purpose than self-defense, something like that. And depending on whether the regulation got to the core of the right or was more tertiary, it would apply varying levels of scrutiny. And effectively, this second step allowed courts to validate regulations of firearms that would not have existed around the time the Second Amendment was passed. In Bruin, Thomas and the majority said that is not the approach that you can use going forward. The only question is the first test, whether this type of regulation existed at or around the time the Second Amendment was adopted. Using that approach, the court looked at a number of historical examples of firearm regulation and determined that the New York statute wouldn't have been around during the time the Second Amendment was adopted and was therefore invalid. This is significant for, at least in the immediate term, at least 6 states and the District of Columbia, which have what are called may issue firearm licenses, as opposed to shall issue firearm licenses. So in the may issue states, you have to show there's some kind of discretionary aspect of the licensing scheme where you have to show you really need the firearm for a particular purpose. Where in shall issue states like Minnesota, you have to just meet a standard set of licensing requirements and are basically allowed to get a firearm. The court had a number of concurrences and dissents. The most interesting concurrence is probably from Roberts and Kavanaugh, in which they clarified that even though they are essentially broadening the right to keep and bear arms or recognizing a broader aspect of that right, there are still regulations that can be imposed that will prevent you from, going and buying a hand grenade and walking down the street, something like that. And so there still are regulations that they wanted to be clear will be allowed to continue going forward. The dissent started off with a lengthy analysis of ongoing gun violence and talking about different ways in which legislatures have tried to address this, specifically through gun control and regulations, and argued that the Supreme Court in the majority were engaging in a form of judicial activism by essentially wading into this arena and saying this type of regulation is allowed and this type isn't, and basically argued that the majority's approach would lead to more violence, and because the court wasn't equipped to handle the policy implications of their decision. They had a number of other qualms with the majority's analysis, in particular the analysis of the history that the Supreme Court adopted, among a number of other things. So going forward, this will be an interesting to see how the district courts apply this. We've already seen a number of cases handling this and reaching kind of interesting outcomes. One one interesting development is that after Bruin, the New York State Legislature adopted a different set of firearm regulations that seemingly require people to provide a copy of their social media accounts for the last 3 years, which seems to violate Bruin, but and there are some challenges that have come out of that so far, but we'll see how that goes going forward.
The next case is Dobbs. There were two questions that were addressed in the Dobbs decision. Does the Constitution confer a woman's right to abortion? And should the court overrule Roe versus Wade, which held that the Constitution guaranteed such a right? And unless you've been on a 4-week or 4-month trip to the Boundary Waters, where there is no cell coverage or media coverage of any kind, you know what the answers were. The answers were no. In an opinion authored by Justice Alito, the court found that the Constitution did not confer a woman's right to abortion and that Roe versus Wade should be overturned. How did they get there? That's what I want to talk a little bit about. And let me start with Roe and just remind us all what, what Roe was about. This was a 1973 decision. It was authored by Justice Blackmun. It was a 7-2 decision. And it found that a woman had a constitutional right to abortion, at least during the first and second trimesters, though the state could regulate in the second trimester if it could show a compelling interest in preserving maternal health. After the second trimester, the line of viability, according to the court at that time, the state has a significant interest in protecting the fetus. And the court based its decision on what it called privacy and personal autonomy rights that it found in emanating from other decisions, essentially, which emanated from provisions of the Constitution. But it acknowledged that this was an unenumerated right. So it's not a right that is specifically called out in the Constitution. But the court took this balancing approach of a woman's right to personal autonomy with the right of the unborn fetus. That decision was updated in 1992 in Planned Parenthood of Southeast Pennsylvania versus Casey. There, the court, in a 3-way split opinion, held that stare decisis required adherence to Roe's central holding that a woman has a right to abortion and that the state may not constitutionally prohibit abortion in early pregnancy. But it found that this viability test was unworkable, and it adopted a new test. This test is a state regulation imposing an undue burden on a woman's right to abortion. So that brought us to, that was sort of the current state of the law that the court addressed in Dobbs. And in Dobbs, the court was addressing a Mississippi statute that was passed in, I think it was 2018, that generally prohibited abortion of an unborn human being, the language of the statute, after the 15th week of pregnancy, several weeks before this line of viability that had been used in the Roe case. The legislatures who proposed this were open about the fact that this legislation was being adopted because of the change in the court, because in the change in the composition of the court in 2018 with the Trump administration putting more conservative justices on the court. Now, interestingly, Mississippi in this case did not say that overruling Roe was necessary, but the respondents in the case and the Solicitor General on behalf of the United States took the position that it was essentially all or nothing. Either you're reaffirming the right to abortion and not overruling Roe, or going the other way. So the holding in Dobbs on this issue of whether or not the Constitution confers a right to abortion was that it did not, because abortion was not, quote, deeply rooted in this nation's history and tradition, and was not, quote, implicit in the concept of ordered liberty. That was the test against which the court measured this right or lack of right of abortion. It also found that Roe was egregiously wrong. Those are the words of the majority opinion. Justice Alito was joined by Justices Thomas, Kavanaugh, Barrett, and Gorsuch. There was a very strong dissent, which I'll come to in a second, that was authored by Justice Breyer. And there was a separate, in many of these decisions, there are separate concurrences. We don't have time to talk about a lot of them. There was one by Justice Thomas in this case that you may have heard about that I think is important, and I will talk about it a little bit. So where did this was the new test. Is this unenumerated right deeply rooted in the nation's history and tradition? Where does this come from? Well, this is a relatively recent construct. There were 3 or 4 cases, Washington versus Glucksberg in 1997, Timms versus Indiana. And incidentally, the Washington case was the right to assisted suicide. Whether there was one, there is not one, according to the court. Timms versus Indiana, 2021, which was the excessive fines case. And another case, McDonald versus Chicago, a 2010 case involving the right to bear arms. And in those cases, although the court had not said this is the test, the court had considered whether unenumerated rights at issue in those decisions were in fact deeply rooted in history or essential to the concept of ordered liberty. So the court in Dobbs takes those that inquiry that was used in these 3 relatively recent cases, and it becomes the new test for whether or not a claimed unenumerated right is essentially conferred by the United States Constitution. So what does the court do? Well, it looks to see whether there was a right to abortion in the nation's history, and it concludes after a survey of historical statutes going back to England up through the date of ratification of the 14th Amendment in 1868, that there was no historical right to abortion in the United States. And in fact, it notes that for much of the period, though not all, there were criminal penalties in many jurisdictions for abortion. So then the court has to deal with these privacy cases. So you may recall there is a series of privacy cases that start, they actually start in the 1920s, but then continue up through the present. And they involve such things, and I'll call them privacy personal autonomy cases. They involve such things as the Loving case, the right to marry a person of a different race in 1967. Griswold, right to obtain contraceptives. Skinner, right not to be forcibly sterilized, 1925. And other post-Casey cases like Obergefell, which was the same-sex marriage case, and Lawrence versus Texas, the case that dealt with sodomy laws. All of the decisions in those cases were based on this concept of personal autonomy and privacy that those courts found within the Constitution. Justice Alito says, however, none of those rights have any claim to being deeply rooted in American history. And so he dismisses them as the basis for the court's analysis about whether the Constitution confers a right to abortion here. But he also says there's an important distinction. He said, he says we're not overruling those other privacy cases because what's different about this case is abortion destroys the life of an unborn human being. Those were Justice Alito's words. There was an equal protection argument that was raised by the respondents in that case. That's dismissed essentially in one paragraph. No real discussion about it. The court finds that the Roe case mischaracterized the historical record and was not based on an historical right to abortion. And Justice Alito is clear that he thinks this is a policy decision and a policy decision that should be left to the states to decide. And he essentially criticizes the dissent, which I'll come to in a second, as standardless. So he says essentially, if we can sort of find these privacy rights and autonomy rights wherever we want, the problem with that is there is no standard against which to measure them. They're basically the creation of the policy determinations made by the justices on the court at the time. And that's wrong. We shouldn't be doing that. So having found that there was no historical right to abortion, that it's not deeply rooted in American history, then the question becomes, should Roe be overruled? So Roe is wrong, says the majority. Now, should we overrule it? Well, as we No, courts are critical of a lot of previous decisions that are wrong, but they rarely overrule the precedent because of stare decisis. But the court engages in a 5-part test, which, as far as I can tell, was developed for this opinion. It looks at the nature of the court's error in Roe. It looks at the quality of the reasoning in Roe. It looked at the workability of Roe. It looked at the effects of Roe on other areas of the law. And then at the end, it considers the reliance interest. Have people, American citizens, relied on Roe? And for the first 4 of those questions, it basically concludes there are good reasons to overrule Roe. On the last, the reliance interest, the fact that American women might have been relying on this for the last 50 years, the court says it is ill-equipped to assess generalized assertions about the national psyche. So it doesn't really address it at all. The result, according to the opinion, is to turn the abortion decision back to the people, i.e. state legislatures. The concurrence, which I've mentioned with Justice Thomas, has been somewhat controversial because Justice Thomas says he agrees with everything that Justice Alito said, but he also says that that Roe was a form of substantive due process, which Justice Thomas has been very clear in other decisions he is opposed to. And he says, so is Griswold, so is Lawrence, so is Obergefell, the same-sex marriage case. And he says we should reconsider all of this court's substantive due process precedents, naming those cases explicitly. Justice Robertson was trying to find a middle path. He's an institutionalist, as we've talked about before. He would uphold the Mississippi law, but saw no reason to overrule Roe. The dissent, and I'll just go through this briefly, notes that for over 50 years, the court had determined that the Constitution safeguards a woman's right to abortion. And it acknowledged that Roe and Casey had recognized that the state has an interest in protecting the life or a fetus that may become a child and sought to balance those interests. But now the court has swung those interests entirely in favor of the state. He notes specifically the reliance interest and really chides the majority for not recognizing that the American people might have relied on this right for the last 50 years and the concept of personal liberty that it embodies. He also notes that unlike other cases in which the Supreme Court has overruled prior precedent, the only thing different about the Dobbs case versus the Roe case was that the court's personnel had changed. That was it wasn't like Plessy versus Ferguson, where when the court issued its Brown opinion, the court had 100 years to determine that separate was not equal. The only difference here was that the composition of the court was changed. And the dissent chides is probably too soft a word, but criticizes the majority for weakening the authority of the court by overruling a case that it just because the personnel have changed on the court itself. The dissent also takes very extreme criticism with the notion that we have to look at, in order to determine whether an unenumerated right was conferred by the Constitution, we have to look into the minds of people pre-1868 when the 14th Amendment was ratified. Note specifically that if that's what we have to do, we're essentially looking back to see what the framers of the Constitution may have intended, which is difficult, and that the framers of the Constitution and those that followed them in the early 19th century were men and who denied the legal existence in many ways of women. And the dissent says that's improper. So the dissent really leaves us with this criticism of Dobbs, in the majority's opinion, as weakening the Supreme Court as an institution and weakening the faith of the American people in the value of the court to make decisions that are unaffected by their personal politics.
Okay, next up we have West Virginia versus EPA. This is a really significant case that addresses the power of federal regulators. And the case arises in the context of environmental regulation, but its impact I think will go much further than that. And so let me do a little bit of table setting background on the case. In the waning years of the Obama administration in 2015, the EPA issued what was called the Clean Power Plan. And the basic idea behind the Clean Power Plan was to compel a shift in electric generation away from coal-fired plants to solar and wind and gas. And the EPA said that existing coal-fired plants basically had three options. They could reduce their output, they could install solar, wind, or gas facilities, or they could engage in a cap and trade program. But the idea was reduce coal, boost up solar, wind, and gas. And the EPA claimed the authority to issue this rule based on the Clean Air Act, which is a federal statute that was enacted in the 1960s. And specifically, the EPA pointed to a provision in the Clean Air Act authorizing it to identify, quote, the best system of emission reduction, close quote, for power plants. That provision was added in a 1970 amendment. It had almost never been used by the EPA. It had only been used a handful of times in the 50 or so years since the amendment. And it was described in the legislative history as a, quote, obscure, never used section of the law. The case had a very complicated procedural history. It wound around various courts for about 6 years, but eventually got to the Supreme Court in 2021. And the issue before the court was, did Congress authorize the EPA to issue the Clean Power Plan? The court said no. The Chief Justice wrote the majority opinion, again, on that 6-3 division, the 6 more conservative justices in the majority. And the court held that the EPA did not have clear congressional authority to issue this Clean Power Plan. And here's the key bit. The court recognized for the first time, formally recognized, a doctrine called the Major Questions Doctrine. The court had applied this doctrine before, but it never formally recognized this the first time. It's pretty simple to state the doctrine. The doctrine says if a federal agency is going to issue a rule that will have vast economic and political impact, it has to point to clear and express authorization from Congress for that rule. So it sort of works in a two-step analysis. Step one, is this rule going to have vast economic and political significance? Step two, if so, you got to point to some statute that gives you that power. So as applied in this case, the court said, okay, first of all, yes, this will clearly have a big impact, right? This plan purports to basically fundamentally change the American energy sector, shifting it away from coal to renewable energies and gas. And on the second question about the second question then is, okay, that's fine as long as the EPA can point to clear congressional authorization for the plan. And the court said there was no such authorization here. As I mentioned, that provision of the law had rarely been used. It was considered sort of an ancillary backwater part of the Clean Air Act. And the court didn't view that language, added in 1970 as giving the EPA clear authority to pass the Clean Power Plan in 2016. There was a concurrence and a dissent. Justice Gorsuch had a very long concurrence in which he provided sort of the intellectual underpinnings for this new major questions doctrine. It's sort of an interesting, fun read. He cites Hamilton and James Madison. He has a whole footnote devoted to Woodrow Wilson. It's an interesting read. There's a dissent written by Justice Kagan, and she offers essentially two criticisms. First, in her view, the Clean Air Act does clearly give the EPA the power to pass the Clean Power Plan. She walks through the text and justifies that position. And second, and this is where commentators I think have noted her probably she landed the best criticism, is this is a really, really hard doctrine to apply. Almost all federal regulations are going to have economic and political significance. How great do they have to be? How vast does the impact have to be before this major question doctrine kicks in? That's the issue that's going to be left to lower courts in the coming years. And I think this decision, and commentators have noted, will have a really major impact going forward. As many people have noted, with continuing gridlock in Congress, federal regulators are frequently relying on very old statutes to address new problems and issue new rules. And I think litigants are likely to use this major questions doctrine to challenge many of those new rules. And all federal regulators, not just the EPA, will need to be able to point to clear congressional authorization for their actions, as long as someone can determine that those actions will have, quote, vast economic and political significance. So look for this major questions doctrine from this West Virginia versus EPA case to rear its head again in the coming years, and I won't be surprised if it'll be back before the Supreme Court soon.
Up next, we have Carson versus Macon. This is an interesting case where the Supreme Court is tackling the intersection between the Free Exercise Clause and the Establishment Clause of the First Amendment. In particular, in this case, the court is addressing a Maine statute that concerns tuition assistance programs. So if you didn't know, Maine has some areas of the state that are extremely rural, which make it almost impossible to establish a public school in those areas. And in order to allow all children of Maine to have an opportunity for an education, Maine created a tuition assistance program that reimburses parents who send their kids to a private school that meets certain basic criteria if they aren't able to attend a public school. The one restriction that Maine imposed was that this money, this tuition reimbursement, could not go to a school that was religious or sectarian, by which Maine means a school that has an association or affiliation with a particular belief system and incorporates that belief system into their teaching methodology. So the petitioners in this case sought to send their kids to a religious school, but weren't given the tuition reimbursement, and appealed to the Supreme Court, which addressed whether that was a violation of the First Amendment. It's kind of an interesting question of how you frame this dispute. And the way you frame it, I think, gives you the outcome of the case. So the petitioners and what the majority ultimately concluded, how they framed it, was that this is a free exercise case, whereas the dissent and the state of Maine argued this is a Establishment Clause case. So the majority was 6-3, like we've seen in a number of other cases, authored by Roberts, joined by the typical conservative justices. And they held that based on some prior decisions, relatively recent prior decisions, if there is a public benefit that's broadly applicable that a entity or person would otherwise be qualified to receive, but they don't receive it solely because of their affiliation with a religious group or organization, that is a violation of the Free Exercise Clause, because the only reason you aren't getting that public benefit is because of your association with religion. The dissent, authored by Justice Breyer, joined by Kagan and Sotomayor, argued that really the court is pushing those prior cases a little far. They're fairly distinguishable because in this case, the court is approving of a statute that under which the state is effectively paying somebody to teach religion. So in the other cases, the court or the statutes at issue were paying for or reimbursing religious organizations for paving a parking lot or a resurfacing a playground. But here, the distinction is that they will be paying for somebody to teach a religious point of view. And that's particularly interesting here because this is a replacement for the public school system. And so based on that, the dissent says this case is really an Establishment Clause case and violates the Establishment Clause. So kind of an interesting issue. It shows a trend that we've seen in a number of cases this term, but also previously, where the court, when faced with a confrontation between those two clauses, is giving more weight to the Free Exercise Clause.
And that is the summary of this case as well, Kennedy versus Bremerton School District. It is another case in which there is a clash, or at least a potential conflict, between various provisions of the First Amendment. You may remember the First Amendment is kind of packed with rights and prohibitions. And there is the free exercise clause. That's the free exercise of religion that Ian was just talking about. There's the free speech clause. And then there's the establishment clause, which says that the government may not make laws in respect of religion. So this case involved a coach's very public prayer at the end of a high school football game in Washington State. And in a 6-3 decision that was authored by Justice Gorsuch, the court held that the coach had a right to make what the court characterized as a personal prayer at the end of a game on the 50-yard line following a high school football game. The school district had argued that this was an expression of a religious view that was incorporated into this official school function, and therefore violated the establishment clause. So in this case, Justice Gorsuch starts out with the statement that Mr. Kennedy, the coach, assistant coach, was fired because, quote, he kneeled midfield to offer a quiet personal prayer, close quote. And it is that framing, and again, as Ian pointed out, framing becomes very important in these decisions. It is that framing that guides the court's decision here. Framing the facts that way makes it sound like the coach had a quiet moment at the end of a game. He uttered a personal prayer. How could he be fired for doing such a thing? And the court looks at whether this was an exercise of free speech, concludes that it was. Is it an exercise of religion? Concludes that it was. Asks the question, was he doing this as a part of his job? Was he promulgating some official position of Christian religion on behalf of the school district? Concludes that that's not what he was doing, and therefore finds that those rights, because they were burdened, require the strict scrutiny analysis that's required under First Amendment jurisprudence, and that the school board could not demonstrate that this was a necessary regulation to prevent violation of the Establishment Clause. And again, as Ian pointed out, when these rights come into potential conflict, the court is again emphasizing the free speech, free exercise clauses and de-emphasizing, minimizing the importance of the Establishment Clause. So when I say framing is important, the dissent raises this directly. It turns out that Justice Gorsuch, of him kneeling in a quiet moment of personal reflection, really is not what happened. And this is well documented in the trial record. The media, who had been invited for this small personal prayer, was also there to document what had happened. What had actually happened was this. The coach had been offering and been incorporating Christian messages into locker room speeches, post-game speeches, and various other communications to his team for many years, and was told to stop it. And in large part, he did. But he wanted to continue making a prayer at the end of the game. And he was doing that. And when he did it, he was joined at first by some, and then later by most of the football players on the 50-yard line. When the school district again told him to knock it off, this is all in the dissent, he decided that he would go to the media and state legislatures. And so when he made this quiet offer of a quiet personal prayer on the 50-yard line at the end of the game, it was duly recorded by the media, whom he had contacted to come out. And he was quickly joined by members of the opposing team and by members of the public who leapt over fences, knocking into and knocking over the high school band to get to the middle of the field to offer their small and quiet personal prayer along with the coach. So Justice Sotomayor in her dissent points all this out. She actually includes photographs. It's a rare thing for an opinion or a dissent to include photographs in an official Supreme Court opinion, but there are actually photographs of all this in the dissent, and really criticizes the court for mischaracterizing what occurred here. But again, to Ian's point, it's the framing of the issue that drives the decision here, and the framing of this issue was an emphasis on the free exercise of religion, which was obviously very important to the majority of the court. And I think the majority of the court, it's fair to say, was prepared to overlook some potential inconsistencies with this characterization of this as just sort of a quiet moment of personal reflection. But again, I think we're going to see this again and again. We're going to see it, I think, in this term coming up, when there is a clash between the free exercise clause and other rights, enumerated or unenumerated in the Constitution. I think the takeaway from this is we can see that religion, the free exercise of religion, is likely to trump other potential rights when there's a potential conflict.
All right, from the First Amendment to ERISA, the natural transition. This case requires a little bit of setup. This Hughes versus Northwestern University. So let me set the stage here. So I think it's probably everyone in the room knows employers typically often sponsor retirement plans like 401k plans for their employees. And in today's day and age, those are typically called defined contribution plans, right? You contribute to an account on a tax-deferred basis. You get to invest in a variety of different investment options. And then at retirement age, hopefully there's a big balance that you can collect. Those plans are governed by a federal statute known as the Employee Retirement Income Security Act, or ERISA. And under ERISA, the people who manage these and administer these plans are fiduciaries. They have fiduciary duties to their plan participants to prudently manage the plans. Now, ERISA is famous or infamous, depending on your perspective, for generating a lot of litigation and a lot of Supreme Court cases. It seems like every term there's at least one ERISA case, and this year was no exception. It was this Northwestern University case. So Northwestern University sponsored retirement plans for their employees, and some of those employees sued Northwestern, claiming they had breached their fiduciary duties in imprudently managing the plan. They claimed that essentially they had a number of theories, but essentially there were cheaper funds that were available on the market, and they should have put those cheaper funds into the plan. Now, this is important. There's some important context here, which is this lawsuit against Northwestern is part of a huge wave across the country of similar lawsuits. There have been 150 class action lawsuits filed against plan sponsors with virtually identical allegations as was in this case. And courts have really been struggling with figuring out, okay, how much does a plaintiff have to allege to get into the courthouse? What's a plausible breach of fiduciary duty in these situations? The Seventh Circuit in this case said these allegations fail as a matter of law because plaintiffs concede that there were some investment options in their retirement plan that were prudent, that weren't too expensive. And they're just complaining about a small subset of the funds that they claim were too expensive. They had a choice. They could have invested in those admittedly prudent options. So basically, they can't complain about these options that are allegedly imprudent. The court reversed in a unanimous 8-0 decision. And I think it was a very short decision. I think it was probably one of the shortest decisions of the term. And the opinion was very simple. Right? Fiduciaries have a duty to monitor all the plan's investment options. And if you neglect to get a cheaper fund when it's available, that could be a breach of fiduciary duty. That could be imprudent. And just because you offered some good funds doesn't excuse you if you offered some bad funds. So commentators have noted, and ERISA litigators, I think I think everyone is sort of disappointed with this result, not because the Seventh Circuit got reversed, but because commentators were hoping to get guidance from the Supreme Court here on what you need to allege to actually state a plausible claim, and the court didn't do that. Just said Seventh Circuit got it wrong and sent it back to reevaluate whether the allegations were plausible. Given the volume of these ERISA class actions, I would expect a case like this Northwestern case to be back in front of the Supreme Court in the next few years.
Our next set of cases are a trio of arbitration cases. So typically we see the Supreme Court applying very favorable interpretations or decisions that support arbitration. This year, I think, is a little interesting because it's more of a mixed bag. There's some ammunition in here for parties seeking to get out of arbitration agreements. So let's get into the first one, which is Viking River Cruises versus Moriana. This is a case out of California, which effectively held that the FAA, the Federal Arbitration Act, preempts a specific California statute that limited what a let me just back up and describe what the California statute does. It's called the Private Attorney General's Act, and it allowed basically an employee to sue a former employer on behalf of themselves and also other employees. In particular, in this case, the plaintiff was subject to an arbitration provision and also had a class waiver in that agreement. Despite that, the California Supreme Court said the arbitration provision doesn't prevail. You have to litigate these in state court. And the federal court, the Supreme Court said that's incorrect. The FAA preempts that California statute, and you are allowed to basically sever certain claims to go to arbitration and have others go to the California state courts. So this case is an example of one where the Supreme Court is favoring arbitration and saying arbitration does apply over certain state procedural requirements. The second case is Morgan versus Sundance. This is a case out of the Eighth Circuit, and it's interesting because it addresses the requirements for waiver of an arbitration provision. The Eighth Circuit and some other circuits in the past had applied a pretty high bar for proving that a party had waived an arbitration provision. It required the party to show knowledge of the arbitration provision, acts that were inconsistent with arbitration, and third, to show prejudice to the party alleging waiver. The Supreme Court held that the first two elements were a component of federal waiver law, but the third element, the showing of prejudice, was an added element that wasn't really a part of waiver law. It was something that the Eighth Circuit and other courts had just added to arbitration disputes. And the court held you can't do that. You can't add specific arbitration-only procedures. You have to just apply the general procedures that would otherwise govern. So going forward, maybe a little easier to accidentally waive a arbitration provision. The last case is Badgerow versus Walters. This is an interesting case concerning which court addresses whether to confirm or vacate an arbitration award. So in certain provisions of the FAA, the federal court will look through the dispute to the underlying claim to determine whether or not federal jurisdiction exists. And that's important because the FAA itself, even though it may be the basis for some disputes, doesn't provide subject matter jurisdiction to federal courts. So they need an independent jurisdictional hook in order to get into federal court. The Supreme Court said you can't, when you're addressing motions to vacate or confirm an arbitration award, you don't do that same look-through procedure. You don't look through to the underlying dispute. You only look at what is on the face of the motion in front of you. And that's based on a difference in statutory language between the two provisions. So going forward, there likely will be more state courts that are going to be addressing whether to confirm or vacate an arbitration award.
Okay, next up is Kemp, and this is a civil procedure case. It involves Rule 60B of the Federal Rules of Civil Procedure. Rule 60B authorizes relief from a final judgment on a variety of grounds, one of which is if there's been a, quote, mistake. The issue in this case is really straightforward. Does the mistake under Rule 60B include a judge's error of law? Believe it or not, there's been a split of authority on this for about 50 years. Some courts have said judges' mistakes of law are not covered by Rule 60B. Some have said yes, and some have said only certain types of judges' errors. Now, as a practical matter, this doesn't come up all that often because typically if you're the losing litigant, you will appeal to correct an error of law or you'll bring a Rule 59E motion to amend the judgment. But in the event that you blow both those deadlines and you're relying on Rule 60B, you're forced to argue that a judge's mistake of law can be a mistake that will get you out from under the judgment. So the court finally stepped in and resolved this question in a 8-1 decision, ruled that Rule 60B applies to all judicial errors of law. And that's important to stress that all judicial errors of law, because the government had urged a limitation. They had said it should only be obvious errors of law. And the Supreme Court said, no, there's no justification for that limitation. Going forward, the mistake prong of Rule 60B applies to all judicial mistakes, including those of law. There was Justice Gorsuch filed a lone dissent on this case. In his view, this ambiguity in Rule 60 was really a policy question, how to weigh on one hand the need for finality versus the need for error correction, and he would have resolved this through rulemaking, not through judicial decision. But setting that aside, we now have a clear answer going forward. Mistake within the meaning of Rule 60B includes a judge's mistake of law.
So let me just talk for a couple of minutes about 2 death penalty cases and some things that I think are interesting about these cases. So the first case is Ramirez versus Collier. This case involved whether it was a violation of a religious protection statute, essentially for inmates, to prevent a pastor from laying hands on the defendant while the defendant was being executed in the Texas death chamber. And the court concluded that that was a violation of his right, that a pastor should be allowed to put his hands on a defendant who was being executed. What I will say about this case is about 30 years ago or so, Justice Blackmun, who was a pro-death penalty justice, changed his mind. And he changed his mind because he became convinced that no matter how much you tried to adjust death penalty statutes and death penalty regimes to ensure that only the most guilty, the most deserving were executed, and to control their execution, that there was really no way to do that. And what he said was, I will no longer tinker with the machinery of death. Kind of a famous quote in Callens versus Collin. This is the tinkering he was talking about. So the court has uniformly said time after time that the death penalty is not unconstitutional, but it is a violation of the defendant's right if a pastor isn't allowed to touch him while you're killing him. The second case is Tsarnaev, and this is the case involving the Boston Marathon bomber. And I think the interesting thing about this case is the legal issue wasn't particularly interesting. The Court of Appeals had reversed the trial court's conviction here because it found that the trial court hadn't adopted the right procedures in the jury questionnaire and had not admitted some evidence. What I think is really interesting about this death penalty case, which is similar to a lot of other death penalty jurisprudence at the court, is there's not really a compelling policy issue or constitutional issue involved. It's pure error correction. The Supreme Court is not supposed to be an error correction court. That's the job of the Court of Appeals. But when the death penalty is involved, it does exercise an error correction function, and it works both ways. It has corrected courts that have allowed the death penalty, and here it corrected a court that was overturning a death penalty because it held that the procedures were wrong. Okay. All right, for our New York attendees, I need to say that the CLE code is QWR480. I think there's some other states too. That's the code. All right, I've done my job. The Shadow Docket. We talked a little bit about this last year for those of you who attended last year. The Shadow Docket is something that has always existed at the Supreme Court. It didn't have this name until recently, but it is the docket that basically addresses motions, sometimes emergency motions, sometimes direct applications for an injunction to the Supreme Court, and it deals with these kinds of cases in a way that is not on the normal track for decisions. So it isn't the usual, it doesn't have the briefing schedule. Oral argument is generally not allowed, and the court just makes a decision. We've seen, and if we go to the statistics thing, that starting about 2017 and 2018, the incidence of using the shadow docket went up fairly dramatically. And it was used in cases in which essentially substantive decisions were being made by the court without the benefit of full briefing or oral argument on the normal track. And that has engendered a lot of criticism that essentially the court is making law, but doing it kind of through back channels. Justice Kagan has been one of the most vociferous dissenters when this has happened. And we've included her quote here in the Merrill versus Milligan case. Today's decision is one more in a disconcertingly long line of cases in which this court uses its shadow docket to signal or make changes in the law without anything approaching full briefing and argument. The shadow docket was at issue in Whole Woman's Health versus Jackson. I'm going to touch on this very briefly here. You may remember Texas passed a law in 2021 that essentially made abortion illegal. This was pre-Dobbs now, so it's important, who knows. But it made abortions illegal. I believe it was if they were any time after 6 weeks, but it had a twist to it. And the twist was it wouldn't be enforced by state officials. It would be enforced through a private right. Essentially, every person in the state of Texas was allowed to challenge a doctor's decision to give an abortion. And if the doctor was found to have violated it, there were statutory penalties and financial penalties that would be applied. So it was intended to, and pretty clearly did, have a chilling effect on abortion. It was clearly, at the time, it was clearly unconstitutional, right? Because Casey was the law of the land at the time. And Casey did not have a six week deadline for abortion. So absolutely unconstitutional. But it had been designed to prevent essentially the court from enjoining pre-enforcement application of the statute, because you can't, there was nobody to sue. Nobody had brought the case yet. You can't sue state officials under the Ex parte Young doctrine. And anyway, the state officials weren't involved with applying the statute. So there were some pretty critical issues here. But the court decided it wasn't going to, it completely turned down the application for pre-enforcement relief when it came up the first time. When it came up the second time, because there were 4 dissents over the court's refusal to address this and grant cert on it, the court, in a kind of a scattered series of opinions, essentially said, well, the lawsuit can go forward, but we're not addressing the constitutionality aspect of this at all. Again, engendering lots of criticism that the court is sort of picking and choosing in the shadow docket how it deals with these issues.
So 2 of the probably most significant shadow docket decisions from the prior term were the vaccine mandate cases, and I'll just summarize these very briefly. In 2021, the Federal Occupation Safety and Health Administration issued a mandate requiring virtually all private employers, 2/3 of private employers, to require their employees be vaccinated or be weekly tested and wear masks. This was going to cover 84 million workers. And this came up to the court on the emergency docket, and the court ultimately refused to let that rule go into effect. So the decision was a 6-3 decision. Again, that 6-3 decision that 6-3 breakdown we've talked about before. And in essence, the court said that OSHA didn't have the power from Congress to issue this type of vaccine mandate. This is very similar to that EPA versus West Virginia case we talked about earlier. This was a decision that was going to have really vast impact. It was going to apply to 2/3 of the private sector and 80 million employees. And according to the majority, OSHA's typical domain is in work-related dangers. COVID-19, of course, isn't limited to the workplace. So the court stayed that rule and didn't allow it to go into effect. On the flip side, in the Biden versus Missouri case, this was the healthcare worker vaccine mandate case. This was the rule from DHS, which said, if you want to accept Medicare and Medicaid funds, healthcare facilities, you have to require your healthcare workers to be vaccinated, subject to some exceptions. And Unlike the OSHA rule, the court allowed this rule to go into effect. And this was a 5-4 decision. Chief Justice Roberts and Justice Kavanaugh departed from the more conservative justices and joined the more liberal justices to allow that rule to go into effect. The court thought that there was a cleaner fit between the power that DHS had and this vaccine mandate. So they allowed this rule to go into effect. Both of these vaccine mandate cases were decided on the shadow docket. So without, on accelerated briefing schedule, accelerated oral argument schedule. Okay, with that, we're going to turn to a preview now of the term that just started yesterday.
So our first case is a copyright case, Andy Warhol Foundation for the Visual Arts versus Goldsmith. This case concerns the fair use defense in the Copyright Act and whether a work is transformative or not. In particular, Goldsmith is a photographer who took a very famous photo of the artist Prince, and then Andy Warhol used that kind of as a base to create a series of portraits. When Goldsmith found out, she sued, arguing that this was a violation of her copyright. The Warhol Foundation argued this was fair use because the work was transformative. It transformed the meaning of the photograph from, a nice portrait of Prince to commentary about commodification and consumerism. And the Second Circuit held, in contrast to some other circuits, that even though the meaning of the piece had been transformed, because the photograph remained the recognizable foundation upon which the Prince series was built, it was not transformative for the purposes of the Copyright Act. So the court, this term is going to address what transformative means for the purposes of fair use.
Okay, so next up then is the Sacket versus EPA case. This is a really, really important environmental case that involves the Clean Water Act, and specifically does whether and to what extent the Clean Water Act applies to wetlands. So as a reminder, many of you probably know the Clean Water Act applies to, quote, navigable waters, which the act unhelpfully defines as, quote, the waters of the United States, whatever that means. So the Supreme Court has 3 times been called upon to interpret those words and what they mean, and has failed to really provide good guidance to the lower courts, who continue to be confused. This case squarely puts in front of the court, when is a wetland a water of the United States such that it would be subject to the Clean Water Act? Oral argument was heard in this case yesterday. Just 2 little tidbits from that. It seemed like the justices were, most of the justices' questions suggested that they would be open to a sort of a robust understanding of a lot of wetlands would be subject to the Clean Water Act. But there was a lot of reservations about understanding that landowners need clear rules, right? Landowners need to understand, is this bog or marsh on my property subject to the Clean Water Act? So I think the court is going to struggle to, once again, to come up with clear rules in this space, but hopefully we'll get some guidance from Sacket.
The next case is National Pork Producers versus Ross. As we've indicated here, it's a Dormant Commerce Clause case. I know you all remember the Dormant Commerce Clause from your constitutional law class and then instantly forgot it. But it does show up in Supreme Court jurisprudence from time to time. And this case it's a really interesting case. I think the chances that there is a sweeping decision are minimal here, but this could go away, which really would have sweeping impact on the law. So in California, they eat a lot of pork. They eat about 12% of the nation's pork. They don't grow any pigs. Like less than 0.01% of the pigs that are actually consumed in California are raised in California. But California and Proposition 12, one of the famous sort of propositions that have come up, has basically a humane animal treatment law that's vastly more restrictive than the federal statutes, and essentially requires things for the raising of hogs that will be turned into pork that are different, and at least the national pork producers believe ends up having a regulatory effect far beyond the borders of California. And that's the issue. If a statute, this is the issue that's presented in this case, if this statute is demonstrated to have a vastly disproportionate effect on the laws of other states and not really intended to address the situation in California, does that violate the Dormant Commerce Clause? Now, the reason that that could be really important if the court were to say kind of a blanket yes is many states have laws. California is probably the kind of the most notorious, that have very, very restrictive laws that are not followed by other states. But manufacturers, producers conform their laws to California because it is such a large market. So that's true in the car business. It's not only California. Texas has some similar, not animal handling laws, but other laws which have a disproportionate effect on the way commerce is conformed and determined by manufacturers and producers. So this could have if the national pork producers were to succeed here, it could have a real effect on the way states are allowed to regulate.
Our next case is an affirmative action case, Students for Fair Admissions versus Harvard. This will be a big one. Basically, the petitioners in the case are asking the court to reconsider its 2003 decision, Grutter versus Bollinger, which allowed higher education to consider race as a factor during admissions. So that'll be significant, no matter which way the court rules. But in the event that the court does not overrule Grutter, the petitioners have asked the court to consider two specific admissions programs, one at Harvard, one at UNC, alleging basically that, in particular with Harvard, they engaged in discriminatory actions by reducing the number of Asian Americans that were admitted into school. So.
Okay, so we only have 2 minutes left, so I'll be very brief on the next one, this Mallory case, but this is a really important case, especially for corporate defendants. The issue is, if you register to do business in a state, are you consenting to general jurisdiction in that state? The state of Pennsylvania says yes. They have a statute that says if you want to do business in our state, you have to consent to general jurisdiction here. And the Supreme Court's going to decide whether that's consistent with the Due Process Clause.
The last case we wanted to talk about today is 303 Creative LLC versus Elenis. So this is a reprise of a case that came before the court about, I think 3 years ago, the Masterpiece Cake case, which you may remember. So in this situation, a web designer, so commercial web designer, does wedding websites essentially for people who want to do that kind of thing. But she won't do it for gay couples because she says it offends her Christian beliefs and it would be contrary to her beliefs. She says, I'm an artist. You can't force me to make art essentially that is against my Christian beliefs. The state of Colorado says, we're not telling you what to say, but what you're doing is a denial of service. And we have public accommodation laws that prevents discrimination based on status for goods and services. And you are discriminating. So in this case, the court is going to deal again with this sort of clash between free exercise and First Amendment rights of speech and laws that are designed to prevent discrimination. And it'll be interesting, and I would put money on how this one's going to come out. Thank you all for attending. We're right at time right now. If you have any questions, feel free to send them to us. We'll try to respond or contact us. It's been great to see you all in person, and thank you to our webinar participants too. Thank you.
Thank you.